our next speaker, who's going to take us through the recent amendments which make what Dr. Orow just spoke to us about look like simple propositions, is Phil McAloon. Phil's a recent member of the list, but he's a very experienced lawyer, particularly in the governmental area, but also venture else in the private sector. He has a BCL from Oxford, which makes him a smart man, and on questions of statutory construction and the like, he's difficult to beat. So I'll just pass you over to Phil without much ado.
Thank you. Thanks, Michael. So, getting into landholder duty, I'll take us back to the swinging 60s. Ike and Tina Turner specifically. Tina was doing pretty well at that stage and making quite a bit of money. Ike was tending to spend that money just about as fast as Tina could earn it. And one of the things he spent the money on was building a house. And the house had a lounge room in it that's reputed to have had a waterfall and a television set the size and shape of a whale for some reason or other. Now, rock and roll legend has it that a rather cruel member of the rock press visited the house, looked around at this stuff and said to Ike, "Wow, Ike, it really is true. You can spend $1 million at Woolworths." And that's the point. When I hear a story like that, I'm sure like most of you, I think, what are the landholder duty implications of that sort of thing? A waterfall in your lounge room or a TV set the size and shape of a whale? And the reason I asked that question this morning is that as of 1 July 2012 in Victoria, the consequences of that sort of thing might have changed. Why? Because as of 1 July 2012, we had a significant broadening of the duty base with a move from land rich to landholder duty. And that change of name gives you a hint of how the duty base has broadened. And what do I mean specifically? We have PowerPoints. On 1 July 2012, we saw the removal of the 60% landholding threshold that used to apply. So in other words, you're now in the landholding net, even if you're not land rich. So all you need to have is land holdings in Victoria of $1 million or more. And I'm sure, as any of you who have recently entered into the Melbourne property market would know, $1 million doesn't get you too far. So what's gone is the requirement that the company or trust scheme have assets that comprise land, wherever held, that are 60% or more of its assets. So we've gone away from land rich. It doesn't have to be land doesn't have to be a significant or substantial part of the assets of the company, to any company or trust that's holding $1 million or more, which doesn't get you far. So needless to say, we have a broadening of the duty base here. There are more landholders likely to get caught by that, obviously. There are also new entities that are brought into the landholder net that were not caught by the land rich net. So we're looking at listed companies and public unit trusts. Now, admittedly, and I'll point this out up front, there's a much higher threshold to trigger duty liability for those. It's acquisition of 90% or more, and the duty is charged at a deeply concessional rate of 10% of the transfer duty. But watch this space. When has a tax ever gone down? So we've got more entities, and they're more likely to be caught. The amended rules, as Bill touched on, have also altered the aggregation requirements, so it's no longer all aggregating all acquisitions within 3 years for working out whether you've made a relevant acquisition. Now it's you look at all acquisitions whenever occurring, subject to the transitional provisions, and then when the relevant acquisition is made, it's brought to duty, but the duty is calculated by reference to the acquisitions in the prior 3 years preceding that last acquisition. The concept of land, and this I think is an important change, has broadened. It now includes things fixed to land. In the past, we used to use the common law doctrine of fixtures to work out whether things on the land had become part of the land. Now we've got a statutory definition that brings in things that are fixed to the land. And I'll go into talk about this in a minute. I think it's something much broader than just the common law of fixtures. I'm sure it's something much broader than that, and the legislation more or less expressly acknowledges that. I'll also move on to talk about another significant, I think, new head of duty in effect, which is this idea of bringing to transfer duty dealings in economic entitlements. And we'll talk about those down the track. As Bill's already touched on lightly, this covers a whole range of interesting dealings in indirect interests that might relate to land or to a landholder. And as Bill already touched on, sadly, and I use the term ironically, sadly, the just and reasonable exception's out the window, but that's sad for the one person who ever got the benefit of it, now replaced with a narrower concession, and as Bill said, it's if there's an anomalous duty outcome. If there are any questions you have on that, please don't hesitate to call Bill. Now I'll focus on the amendments relating to fixtures, or for want of a better term, the land, the things that are fixed to land, and the economic entitlements. Everything I will say, and I don't mean to annoy you by saying this, will be maddeningly tentative because, of course, this stuff's all new, so we don't have much case law to go on. We have surmise and what the SRO has told us, and the EM, I guess, and hell, maybe the terms of the legislation. Let's start with fixtures, or things fixed to land. Now, new section 73 explains what is included in land for landholder purposes, and consistent with this broadening of the duty-based concept I've already mentioned, we're going to see things included in the concept of land that I think would not have previously been caught. Section 73 makes that clear. For landholder duty, land, in inverted commas, includes anything fixed to land, whether or not the item is a fixture at common law. So it could include fixtures, it will include fixtures at common law, but it could include things that were not fixtures at common law. Whether or not the thing is owned separately from the land, whether or not the thing is notionally severed or considered separate from the land under another act or law. So you might have a pipeline statute, for example, that says, regardless of whatever applies elsewhere, for the purposes of this act, or for general purposes, a pipeline is to be deemed a chattel. Well, that might be what the Pipelines Act says, but this Act will undo that work and say, well, for duty purposes, we'll consider the pipeline as part of the land. It doesn't matter, it's called a chattel elsewhere. That's how we're going to deal with it. Then we move on. Yes, when is a thing fixed to land? And subsection 73(2), because we're dealing with, the legislation talks about, well, we'll count as land a thing that's fixed to land, but when is a thing fixed to land? Well, subsection 73(2) will tell you a thing can be fixed to land by a physical connection. So I put the wording there, can be fixed to land by a physical connection. Now we're left to wonder what physical connection might count. I mean, obviously, if you've got something bolted to land, well, there's a physical connection to land. But let's imagine you bring an electric pump onto some land. It's on some metal skids, so it can be moved about, but you plug it into an outlet that's on the land. It will, strictly speaking, be physically connected to the land, but surely that's not what would be considered to be connected to the land, and I don't think that the revenue would argue that it would be. I guess my question is, and we'll go on to consider some practical cases, is where's the dividing line between fixed to land and not fixed to land, connected to the land or not connected to the land? Slightly spookily, the EM then goes on to say a thing can be fixed to land when it rests on land by its own weight. And then it refers to the fact that the common law doctrine of fixtures recognised this possibility. So we have the idea of fixed to land, physically connected to the land. That's in, nice, simple statutory test. But then we get back into the murky world of, well, when is a thing fixed to land? When it's on the land by its own weight. So, for example, when is that dry stone wall part of the land? You know, it's not embedded in the land, it's not stuck to it by mortar. When is it part of the land? Well, I think we have to go back to the common law doctrine of fixtures again. So we're not out of having to look at our property law textbooks when answering landholder questions. Moving on, I should say before I move on, other jurisdictions have used the terminology of fixed to land. At the moment, there are a few that have that in their extant duties legislation. So you've got Queensland, Northern Territory, South Australia, all use the wording, the incantation fixed to land. So there might be jurisprudence coming from those states and that territory that might help us work out what fixed to land means. I had a quick look the other night and I couldn't see much that immediately would have helped us. What I did notice was, under the WA Stamps Act 1921, the old Act, now gone, that also, towards the end, used the terminology of fixed to land, and there's an excellent judgment that I've put in the paper, Epic Energy, Pilbara Pipeline and Commissioner of State Revenue, considering, amongst other things, what fixed to land might have meant. And I do note that, unsurprisingly, President McClure's judgment in that gives some extensive and, I think, unsurprisingly excellent analysis of when something might or might not be fixed to land. Unfortunately, of course, what you're left with at the end of that analysis is, well, it might well depend on the circumstances. Well, gee, thanks. What else is included in land under Section 73(3)? Well, tenants' fixtures are counted in, and I can hear a sharp intake of breath. Oh no, does that mean I get taxed for something I don't own? But it's not as bad as it seems. It's tenants' fixtures within the meaning of Section 22(a), which of course means if the Commissioner is satisfied that they're not being transferred with the land and don't belong to the landowner, then they won't be counted in. So tenants' fixtures are out, most likely. Some things are also specifically excluded from the definition of land. Unsurprisingly, goods that are excluded from being dutiable property are also excluded from being land. So stock in trade, materials held for or used in manufacture, goods under manufacture, etc. The Commissioner may determine that land does not include a thing fixed to that land if the thing is not owned by the landholder and is not used in connection with the land, so subsection 73(5). And the explanatory memorandum explains what might be meant by that. It says, it gives the example of a farmer. So we take the example of Farmer Jones, well, company or trust, that owns a farm, say it's a sheep farm, and on that farm is a wind-powered turbine that generates electricity. So presumably that's been put on there by someone like Energex under a statutory easement under the National Electricity Law. The turbine is on the land, it doesn't belong to the farmer, it generates electricity that runs along a cable that runs on a statutory easement off the land and into the national grid. The windmill is not owned by the farmer and it's not used in connection with the land. So in that circumstance, the Commissioner may determine that the thing is not included in the land, and it would be, that's scarcely surprising. I mean, it does raise interesting questions when there are statements like that in the EM or in general guidance provided by the Commissioner. This question of whether statutory discretions like that can be fettered by these sorts of prior statements. But, I mean, this is pretty safe ground. It'd be pretty extraordinary if the Commissioner didn't exercise the discretion like this. But I raised the point. The main issue I think we have to take away from the new landholder provisions in relation to land is that even with these exclusions in mind, lots of things may be deemed to be land that may not have been land under the old Landrich provisions, and indeed wouldn't have been land under the old Landrich rules, I would say. To take an example, and I'll just black that out for a moment. To take an example, things that might be included in, let's consider the case of Unichema. You've got cogeneration equipment, and this is a case that dealt with the common law of fixtures. A lessee puts cogeneration equipment on the land to provide steam and electricity to the landlord, and there's an agreement that the plant and equipment that's used to do that will be removed at the end of the lease, and there's a make-good provision as well. So when the court was asked to determine that, it applied the old common law questions that you apply to determine whether a thing's a fixture. You consider the degree of annexation to the land. So in that case, it was bolted down, but it could be unbolted and removed relatively easily. But also you consider the next step, which is, well, it's not just that the thing is fixed to the land. We have to ask, why was it fixed to the land? So the purpose of annexation is the next necessary element of the common law doctrine of fixtures. And in that case, the judge said, well, why was the thing put there? Well, it was to provide a service to the landowner. And the thing can be unbolted, albeit it takes a week, and it's meant to be unbolted at the end of the lease or when the landlord says it should be, and taken off the land and dissevered from it. So in those circumstances, well, in that case, the court said, well, that's not going to be a fixture. And indeed, it's often that question, the purpose of annexation, that's the determinative factor under the common law test. Now, of course, with the new statutory rule, which deems things that are fixed to land to be part of the land, you stop the inquiry at the stage of, is it fixed to the land? If it is, it's in. You don't ask, why was it fixed to the land, or is there an intention of the parties that it be removed from the land and be treated as a chattel? No, you don't get into that inquiry. So in fact, the second question in the common law doctrine of fixtures, which has been so determinative in so many recent or relatively recent fixtures cases, is just out the door under this rule. So in some ways, the rule has one laudable effect, which it simplifies the analysis. Admittedly, there might be questions about what counts as a physical connection, but nevertheless, you don't have to get into the sometimes difficult question of, well, what was the purpose of annexation? But that does mean you are sort of adapt something Brennan has said in another context, you are fracturing a skeletal element of the common law doctrine that is being here used for statutory purposes. So would Unikema have resulted in a different answer? Well, under the new 73, I think it probably would have. The things, the plant and equipment's fastened by big, heavy bolts to the land. Well, chances are it's going to be fixed to the land. You might have arguments about less significant degrees of affixation, but that one you'd think almost certainly would be in. What about some other cases? What about those old 45-tonne printing presses that were bolted to a concrete slab so they wouldn't shake themselves to pieces when they were used, so they could be used better as printing presses? Well, you might point to some High Court authority that would give you at least some straw to make bricks with when you're arguing, well, the purpose of annexation, Your Honour, is that the thing be unbolted and taken away, and the purpose was so it could be better used as a machine. It's not necessarily for the better use of the land. Now, I realise there are other cases pointing the other way, but at least you've got an argument. What would you have under the new 73? Well, I'd say not much. I mean, it'd be a brave person who would say to the judge, well, granted, connection to the land must mean something, but it might involve questions of fact and degree. And, Your Honour, there are bolts this big with nuts the size of my head holding this machine in place, but we're going to submit that it's not physically connected to the land and therefore not fixed to the land. Well, good luck with that one. Chances are you'll end up with a different answer from what the common law would have given you. Perhaps a case nearer to the penumbra. I mean, I've already talked about plugging it in. Surely that doesn't count as a physical connection to the land. But what about a case a bit nearer to the meaningful penumbra of this question of whether it's connected to the land? I've dealt with a case like this. You've got a data cable that's running over land and it's stuck in place with things not much more than tent spikes. And the only reason you do that is to keep it in its statutory easement and to make sure it doesn't get bent and kinked by the workers that work around it. You can pull the spikes out and you roll the thing up, and in fact that's what the intention is, because technology moves on and you might want to use this expensive bit of cable elsewhere. So you can roll it up and you can move it around. Would that be fixed to land? And well, maybe you could make the argument. My suspicion is it might well be regarded as fixed to land and therefore part of the land. Is it a more difficult question if it's stuck on with, inch-long staples? A different question again. I just raised this to say the statutory test does simplify things, but it doesn't simplify everything. And indeed, where the question is whether a thing that is not physically attached to the land is nevertheless part of the land by resting on it of its own weight, that question, I suspect, will throw us back to the common law doctrine of fixtures, which, as we all know, is so clear and coherent that we can only embrace the fact that some of it continues to exist. So the drawbacks of this semi-simplification are that it may deem goods to be part of the land that would not normally be regarded as the land, and those things will be taxed at transfer rates as if they were part of the land. But I suppose that's just a reflection of the fact that stamp duty, like any tax law, is positive law, so it's whatever the legislature wants to tax. The fact that it might not doctrinally fit as the concept of land, well, tough luck. The legislature can tax moustaches, it can tax fireplaces, it can tax windows, and it's done that in the past. Not our legislature, but others. So it leaves us with the question, would Ike Turner's whale-shaped, whale-sized television be part of the land? Well, I suppose that question might depend on whether the fact it's plugged in means it's physically connected to the land. I suspect it wouldn't be on that ground, but nevertheless, I suspect we would be thrown back to the common law of fixtures. What about the waterfall? Well, I think you'd have been in anyway there, but you're now definitely in because it's definitely fixed to the land. So some interesting questions about land. We don't have to throw out our copies of Peter Butt on land law just yet when we're dealing with the landholder provisions, in particular in relation to whether things are fixed to land or not. Bill's already touched on the next aspect of this, and I'll move along. I note that, by comparison, the general interpretation provision for the meaning of land is much broader. In all acts and subordinate legislation instruments, unless the contrary intention appear, land includes building and other structures permanently affixed to land. So there we've got something rather narrower than fixed to land. So there's a hint that fixed to land means something different, perhaps, from permanently affixed to land in the manner of a building or structure. And once again, interesting questions how a general interpretive provision like this interacts with a more specific carve-out in duties legislation. But that's a side issue, and I'll move on. Now, Bill's already talked about this other aspect of the new provisions, which is dealings in economic entitlements. And these are being brought to duty. And what does it mean? Well, it's the acquisition of economic benefits, the economic benefit of land, or in relation to a landholder, where you've got the economic benefit, but you haven't got it by way of a relevant acquisition. It's described as an anti-avoidance type provision. I'll get back to that because I think that's slightly unfair to the people who've been dealing in fairly unprepossessing, fairly unexceptionable dealings. To call them tax avoiders, I think, is a bit harsh. To adopt a farming analogy to have in mind, just to get the gist of this sort of, I suspect, well, I'll call it new head of duty, it's where you get the cream without having bought the cow, if you see what I mean. You get the right to the cream, but you don't have to own the cow. That's someone else's headache. Described as anti-avoidance, where to catch cases where acquirers have in substance made a relevant acquisition, but they have done so in a form that's not caught by the present provisions. It applies to the acquisition of shares or units or an arrangement under which an acquirer is entitled to all or any of, to participate in the dividends or income of the landholder, to participate in incomes, rents or profits from a landholder's land, to participate in capital growth in a landholder's land, to participate in the proceeds of sale of that land, to receive any amount determined by reference to the amounts referred to above. So we're dealing here with derivatives. You know, you'll get an amount equivalent to the proceeds of sale of the land. And also it applies to an entitlement to acquire any of the above entitlements. So we're pinging options as well. Importantly, it only applies in relation to private landholders, so private companies, private unit trust schemes and wholesale unit trust schemes. And it applies where the acquirer acquires an interest or an entitlement equivalent to 50% or more of the landholder. So I suppose it's interesting. I mean, if you, under the general provisions here, you get caught if you're acquiring 20% or more in a private unit trust. So if you go under this provision of getting the economic entitlement, where you go with 50% or more, so there's an interesting wrinkle in possibly different thresholds in relation to the one type of entity, it seems to me. It's described as anti-avoidance, and I've already hinted that I think that's a slightly, well, it's a slightly overambitious characterisation because it'll catch things that are avoidance, there's no doubt about that, but it'll also catch things that were not meant to be avoidance, that have been unexceptionally regarded as the sorts of things people do for years and that have not been regarded as an attempt to avoid duty. It's just been that these are the sorts, due to wrinkles in the way the Duties Act is constructed, these sorts of things have not been brought to duty in the past, but they will be now. What am I talking about? Financing arrangements, hedging arrangements that are used to manage risk. What do I mean by way of a practical example? Well, the SRO, I think it's great that the SRO does give practical examples. I think it's principled and brave for them to say, well, this is how it's meant to work. So I do applaud them for that. The SRO gives some guidance on this head of duty. It says, for example, a unit trust's sole asset is a block of land, but it lacks the finance and the expertise to develop that block of land. So it enters into an arrangement with a property developer. The property developer, under a power of attorney, is going to have the power to build apartments on the land, raise finance, build apartments, then go off and sell the apartments, use the proceeds to pay the costs of doing this development, and then the agreement is that we'll split the profits with the private unit trust 70-30. The developer gets 70% of the profits because it's done all this work to develop the land. Now that's a sort of, you know, in a very broad strokes, financing arrangement of a sort that's been around for a long time. But of course, under the economic entitlement provisions, the SRO correctly advises, I suspect, that the developer has acquired a right to participate in the proceeds of the land, so has acquired an economic entitlement for the purpose of these provisions. It has acquired 70% of this economic entitlement, and as a result, and bearing in mind the unit trust has nothing else, we're just assuming for the moment, it has acquired an interest equivalent to 70% of the value of the unit trust. So it will be caught in the landholder duty net. Now, was this an example of avoidance, or was it an example of a fortuitous minimisation of tax as a sort of incidental aspect of an unexceptionable and well-established sort of dealing for the purpose of finance? And there could be other cases caught by economic entitlements, some of which, as I've said, would involve avoidance, some of which are fairly vanilla financing and risk management arrangements. So, for example, you would catch a landholder that strips out a right to the income from land and sells it off. So I've got my bundle of sticks that's property. One of the bundles of sticks is the right to profits in the land. Well, I'll sell that, I'll hive that off under a contract, someone else can get it. Well, that person might well get caught. Dividend swaps would also be caught. Rent futures would be caught. Futures calculated by reference to the capital growth in the land would be caught. And as I've already mentioned, derivatives, those marvellous financial products that have done so much for the world economy, would also be caught under these provisions. So there could be very interesting and complex questions about how you value economic entitlements like that, like, for example, futures. There could be an interesting question whether these are, in essence, really, truly anti-avoidance provisions or really just another head of duty. Bearing in mind land-rich duty started its life as an anti-avoidance provision or set of provisions. So here we have anti-avoidance provisions to the anti-avoidance provisions. So provisions to prevent avoidance of the anti-avoidance provisions. And I'm sure that as the finance industry invents derivatives on derivatives, we'll end up with anti-avoidance provisions dealing with these anti-avoidance provisions and really disappear somewhere not very pleasant. Anyway, I'll stop there. Land-rich duty started as anti-avoidance and has morphed into a head of duty. I suspect economic entitlements, let's bell the cat now and say, well, it's a new form of duty. It will also raise something the late, great Justice Hill used to raise about land-rich provisions, which is how far does the extraterritorial application of these provisions go? What's the constitutional competence of the Victorian legislature? He talked about, well, you could have dealings offshore that have nothing to do with Victoria other than the fact that they are linked to land in Victoria. Well, here we're going even a step further. You could have a Japanese company and a US company dealing with each other in Delaware, dealing in options to acquire derivatives that are valued by reference to the value of Victorian land. That's the extent of the link to Victoria. Well, there could be an interesting question for a quixotic pro bono barrister to raise a question, well, how far does the constitutional competence of the Victorian legislature stretch? What level of territorial nexus do you need? So in closing, to sum it up, the move from land rich to landholder broadens the duty base. There are more entities caught in it. What's counted as land is more expansively dealt with. It no longer limits aggregations to the last 3 years. It brings derivatives into the landholder duty net. Land-rich duty began as an anti-avoidance provision and has morphed into a substantive head of duty in its own right. We have now also seen the birth, I suspect, of another head of duty, economic benefits. So thank you very much.
Thanks, Phil, for creating more headaches. Are there any questions for our speakers? Yes.
Sorry. Phil, you spoke about tenants' fixtures from the perspective of the owner of the fee simple interest in the land, but what about the tenants' fixtures from the perspective of the holder of the leasehold interest in the land? It seems to be an interesting one, and my understanding is that the Revenue Office is starting to take an approach where they are saying that the leasehold interest is an interest in land and the tenants' fixtures themselves are a separate interest in land which could be brought to duty.
Yeah, I suspect you're right. I mean, certainly for the purpose of getting you into, if you're asking is the lessee caught in the landholder duty net, the landholder duty net does not have the same things excluded from it that Chapter 2 does. So you could have a lessee brought in and their leasehold interest counts as land and their fixtures count as land for getting in to the net. Then, of course, when it comes to the imposition of duty, the lease goes out because new 89D, which just picks up what was already there, which is, well, if it weren't brought to duty under Chapter 2, it won't be brought to duty here. The lease would be counted out for the actual imposition of duty. Correct me if I'm wrong, Bill, you may well have a different view.
That's right.
Now, as for where does that leave the fixtures? Now, that's an interesting question. They do talk about this in Epic Pipeline, the Epic Energy Pipeline case, about whether you need an underlying interest in land that relates to the fixtures. And in that case, they said, no, it's enough you have the underlying interest in land. The fixtures could arise by a separate right and be brought to duty, I suspect, in and of themselves. I mean, maybe that's consistent with metal manufacturers, Eastern Nitrogen, those sorts of ideas. I don't know, Bill, what do you think?
I'm not sure. I don't have a fixed view on it.
Fixed to land.
My take on it is that, to my mind, you shouldn't be actually taxed on it unless you've got a special lease that would be caught on a transfer of the actual lease, and that would be an exempt acquisition, so you'd have to lodge and claim that. But then my understanding is that the Revenue Office is starting to think that they can say you just need a lease to get in, but once you're in...
Yeah, I mean, it's a really interesting question, because I think if the lease weren't counted in, the lease is the only reason you've got these fixtures, the only reason you've got this land, you'd sort of think, well, a lessee who owned fixtures, well, that wouldn't necessarily be caught under Chapter 2. Why should it be caught under Chapter 3? I think it's a really interesting question. I think you or one of your clients should definitely pursue it in the court and clarify it for us. Educate the rest of us at your expense, please.
Well, it's a very good question because it goes to the very thrust that this is really a transaction tax. Any other questions?
I just want to make one comment insofar as the economic entitlements are concerned. It was said, but I just want to emphasize it. It doesn't only deal with instances where there is an acquisition of shares or units, but it deals with instances where there is an entry into an arrangement so that you acquire no interest of any kind in the company or trust that holds land, whether it is the landholder, but you enter into an arrangement. Such an arrangement probably will be contractual of some form, and then, of course, you then look at the entitlements that you have. It is very difficult to conceive of an arrangement that involves some kind of a joint venture where some party does not have some participation in the proceeds or some entitlement to profit. And if you look at those words, they are so broad. So effectively, most of the joint venture arrangements that don't involve disposals of land or creation of interest in land would now most probably be caught by this provision.
Excuse me, one thing that may be caught on that basis are directors and executives' performance bonuses where they're related to companies that have interests in land or things that can be created or classified as land because their bonus is related to either profits or increase in market value, increase in share price, which is derived from increase in the value of the land, and it's a direct relationship to those values. So they may find they pay stamp duty on their remuneration.
I don't think that that is their participation in an arrangement, though. Well, this is more ancillary rather than a participation in the arrangement, but it's a good point. Perhaps find someone that will need advice.
No, thank you.
Well, it's an interesting point because the legislation extends to participation in capital growth. So it expressly contemplates circumstances where there won't be a realisation of the asset. The mere fact that it's increasing in value is sufficient. So you can see both ways.
Entered into an arrangement.
Well,
the director wouldn't have entered into the arrangement that relates to the land. The arrangement they have is with the company that relates to its profit performance. And such profitability may be determined by reference to a particular project or movements in its share price. But anyway, it's an interesting question.
It's a good question. Any other questions?
Sorry, just me again.
Yeah.
Just on that point, one other interesting one is whether the director's entitled to 50% or more would be
Yeah, there you
one
go,
that
that's a good point.
might actually get out. Just on the economic entitlement point, wondering what your views are on at what point in time does it kick in, if you like. So if you enter into an arrangement where you would be entitled to, say, 70% of the profits from any land that the entity subsequently acquires,
Yes.
whether you think that that could trigger duty at the point in time when land is actually acquired?
There is a provision that deals with that, so I don't want to answer without looking it up, but there is something that tells you exactly when the liability arises and when you have to discharge.
Thank you.
Yeah, down the back there.
So, sorry,
sorry.
just one question for Bill in terms of economic entitlements. So is it the case that if there's an arrangement between a discretionary trust and a developer, that's not going to be caught by that section?
I don't entirely understand the question. Is the discretionary trust a landholder?
Well, I was just picking up on Phil's comments before that the application is, I think he said it was to private companies and to private unit trusts. So if it's a discretionary
The
trust...
discretionary trust would not be caught. It's not a private landholder.
But,
Yeah.
but if there is a dealing in respect of a landholder, which is the shareholder of the unit trust, which is linked to the private unit trust, the discretionary trust that brings it in, the answer would be yes. But you still have to have the dealing that triggers the duty.
Yeah, it'd be more where the company is acting as trustee of a discretionary trust and they enter into an arrangement with the developer.
You're talking about a company that's trustee of a discretionary trust.
Correct.
Enters into an arrangement with a unit trust.
No, with a developer.
Um,
So the company owns the land and they're the discretionary trustee
yeah.
and they enter into an arrangement with the developer and there's participation in the profits, etc.
But the company in that instance would not be a landholder.
Yep, well that's the
So
question I was...
essentially you would have a Chapter 2 question rather than Chapter 3.
Yep,
In that particular instance, you ask yourself whether or not you have created an ownership of some kind or a change in beneficial entitlement.
Yep.
It's very difficult to conceive of an instance where simply a developer entering into an arrangement with a discretionary trust that gives them an ownership or beneficial ownership entitlement in respect of the land, unless, for example, they affixed things to it in circumstances or pursuant to a contractual arrangement similar to what happened in Eastern Nitrogen and Metal Manufacturers, which gave them what the court described as an equitable interest in the underlying property. Save and except for that instance, you shouldn't have an issue.
yep.
Sorry, down the back. Behind you, Michael.
The threshold, the kick-in point for Section 81, that's 50%, isn't it?
Yes.
Across the board,
Yeah, mine
irrespective
is
of
not going to be
company
easily
or
calculated all the time.
private unit trust scheme. Okay, then we're looking at a private unit trust scheme and somebody wants to acquire an interest in it, effectively an interest in it. If they do it directly, and it's 20% or more, subject to duty,
Yeah.
would the anti-avoidance provisions in the new regime kick in if you create a proxy for a direct interest and then put yourself in line for an assessment under Section 81, but you stay under 50%, but you've got more than a direct 20 in economic value?
A lot of good lawyers would say that depends on the facts.
It's a sensational answer.
An anti-avoidance provision, in that particular instance, the effect would be to incur duty that is less than it otherwise would be. But what is the purpose of it? And that, of course, depends on what the parties did and how they did it. It's an objective purpose to be inferred from the facts as they are played out. I suspect if all you did is you have a choice between buying direct interest or entering into a profit participation arrangement, and you say, well, profit participation, I need more than 50% to be caught, whereas a direct interest, 20%, I'm going to choose the other one. I don't think, without more, I don't think that that's enough to bring you within the general anti-avoidance rule.
So you go to proxy every time, wouldn't you, rather than the direct?
You could describe it like that.
And I suspect, I mean, it'd be a difficult argument from the revenue's perspective to say, well, you are actually doing this in accordance with provisions in the Act that allow for this to happen, to then say that's a...
Well, you basically made an election, haven't you?
Bear in mind, the choice doctrine has been rejected. We used to have a choice doctrine in Australia, which was developed by Sir Garfield Barwick. The High Court has rejected that in recent years. So The fact that you have a choice under the legislation is not enough to get you out of the anti-avoidance rule.
The question is the question is one of significant purpose. Anything else? I'll finish by thanking our speakers for an interesting discussion of some very difficult issues that I think is going to create a lot of headaches for practitioners, particularly the transaction lawyers on whom the onus of getting all this right falls, the advice to clients and the checklists on your transactions. And I'd just like you to thank the speakers in the usual way.